नमस्ते सर।
नमस्कार मजुमदार साहब, क्या हाल
जी
है?
सर, कैसे हैं सर आप?
बस चल रहा है।
तो आज सर हम लोग यही डिस्कस करते हैं, मानेका गांधी केस।
लास्ट टाइम हम लोगों ने यही छोड़ा था।
मैं यहीं छोड़ दिया था।
हाँ, तो इसको ये एक बुक है जिसको सोली सराफ जी की डॉटर ने लिखा है। तो एंड दिस इज आउट ऑफ 10 important जजमेंट विच हैव अफेक्टेड द इंडियन सोसाइटी। उसमें से पहला जो जजमेंट था वो केशवानंद भारती के बारे में था। ये
जी
सेकंड जजमेंट है जिसके बारे में ये जिया मोदी लिख रही हैं। तो दिस केस pertains to impounding of the passport of Maneka गांधी। तो चलो ठीक है, शुरू कर देते हैं विदाउट डिले।
जी
क्या बोल रहे हैं ये?
सर। जी सर। The impounding of Maneka Gandhi's passport. The Maneka Gandhi case arose in the period immediately following the end of the national emergency in India, with the Janata Party government assuming power in 1977. Maneka Gandhi, daughter-in-law of the former Prime Minister Indira Gandhi and founder editor of a political magazine Surya, was issued a passport in 1976 under the Passports Act. Soon after, the Congress party was ousted by the Janata Party. She began using Surya as a political platform to restore the image of the Congress party and discredit leaders of the new government. The most notable instance of this was when Surya carried photographs showing the son of the then Defense Minister Jagjeevan Ram engaging in sexual intercourse with a student of Delhi University. In 1977, around the time she wished to leave India to fulfill a speaking engagement, Maneka Gandhi received a letter stating that the Government of India had decided to impound her passport in public interest under Section 10, subsection 3 of the Passports Act. C, sorry, 10.3c of the Passports Act. The government turned down the request, seeking the reasons why the order had been passed, stating that it was not in the interest of the general public. In reaction, she filed a writ petition to the Supreme Court challenging the passport impounding order of the Government of India and its subsequent refusal to provide reasons for the same.
दादा एक मिनट, इसमें रेफरेंस दिए हुए, थोड़ा रेफरेंस पढ़ते हैं। रेफरेंस क्या बोल रहे हैं?
तो इसमें दिस इज द बैकग्राउंड ऑफ द केस।
27 में क्या बोल रहे हैं, थोड़ा देखें। ये क्या है?
स्पीकिंग एंगेजमेंट मतलब ये, अच्छा
27 में
ये
बोल रहे हैं
फुट नोट
एंथोनी लेस्टर द ओवरसीज ट्रेड इन द अमेरिकन
क्वींस
बिल ऑफ
काउंसिल,
इंडिया। ओके
क्वींस काउंसिल,
ओके, एक तो ये
ये
हो गया।
कोलंबिया लॉ रिव्यू मैगजीन है, उसमें ये आया था। मतलब
दूसरा ये
इसलिए
है
ये रेफर
28, ये है पासपोर्ट एक्ट के बारे में।
The passport authority may impound or cause to be impounded or revoke a passport or travel document if the passport authority deems it necessary to do so in the interests of the sovereignty and integrity of India, the security of India, friendly relations of India with any foreign country, or in the interests of the general public. इसी धारा के आधार पर पासपोर्ट
29
impound कर दिया गया।
29 क्या बोल रहे हैं? हाँ,
It was later discovered that the primary reason for the government's decision to impound Maneka Gandhi's passport was its fear that she would flee India to avoid giving testimony to a commission of inquiry set up to investigate crimes committed during the emergency involving her husband. See Manoj Mate, The Origins of Due Process in India, the Role of Borrowing in Personal Liberty and Prevention Detention Cases. Berkeley Journal of International Law, Volume 28, 2010, page 216. तो
ये
बैकग्राउंड पता चल गया। अब यहाँ से पढ़ता हूँ। Before discussing the Supreme Court's decision in Maneka Gandhi, it is important to note that the rigid approach adopted by the Supreme Court in Gopalan's case, holding that number one, each fundamental right is distinct and must be read in isolation, and two, the expression personal liberty under Article 21 excludes those freedoms that are categorically provided for in Article 19, had been significantly diluted in two cases decided by the Supreme Court in the pre-emergency era. I think the two cases are A.K. Gopalan and Khadak Singh. I think so. हाँ, नहीं, खड़क सिंह एंड आरसी
RC
कूपर.
Cooper.
आई एम सॉरी सर, आरसी कूपर. लेकिन
Khadak
गोपालन
Singh is
कॉन्टिनेंटल
63
है.
and RC Cooper is
हाँ,
70. Okay.
but they've also referred to गोपालन also. Yeah, ठीक है सर, doesn't matter. These cases were extensively cited in the judgment of the Supreme Court in Maneka Gandhi. In Maneka Gandhi, the Supreme Court departed from the straight-jacketed interpretation of fundamental rights in Gopalan and held that the fundamental rights form an integrated scheme under the Constitution. The court stated articles dealing with different fundamental rights contained in Part 3 of the Constitution do not represent entirely separate streams of rights which do not mingle at many points. They are all parts of an
An
integrated
integrated scheme.
scheme in the Constitution. Yes, sir. Their waters must mix to constitute the grand flow of unimpeded and impartial justice. Isolation of various aspects of human freedom for purposes of their protection is neither realistic nor beneficial. Then, emphasizing the need to read Part 3 of the Constitution in a holistic manner, the Supreme Court said that the mere fact that that a law satisfied the requirements of one fundamental right did not exempt it from the operation of other fundamental rights.
Very
What this means
important, very
is,
important, very important. Okay, अच्छा.
फिर से पढ़ता हूँ,
Hmm,
merely the fact that a law satisfies the requirement of one fundamental right did not exempt the law from operation of other fundamental rights.
Means all fundamental right
What
have
this
to
means is, even
go
if a law
simultaneously.
G, were ostensibly associated with a particular fundamental right and complied with its requirements, it would also have to satisfy the requirements of other fundamental rights. The majority on the seven-judge bench stated that any procedure established by law under Article 21 would have to be fair, just, and reasonable, and could not be fanciful, oppressive, or arbitrary. If this standard were applied, the government's impounding order, passed without providing a hearing nor furnishing any reasons to Maneka Gandhi, failed to satisfy the mandate of Article 21. That means, prior to the impounding order, she should have been heard in person.
Hmm.
The court affirmed the decision in Satwant Singh's case and held that the right to travel abroad fell within the sweep of the right to personal liberty under Article 21. The court also found that the government order was arbitrary and violated the right to equality under Article 14. तो इसमें 14, 19, 21 तीनों को इन लोग देख रहे हैं. They have taken the three articles into consideration in spite of its emphatic
Just a minute.
observations.
The court
जी सर.
affirmed the decision in Satwant Singh
Satwant Singh
and held that right to travel abroad
abroad
fell
fell within
within
the
the
sweep.
sweep of the right to personal liberty, that is 21. And then court also found that the government order was arbitrary and violative of the Article 14. बराबर है?
हाँ, जी जी जी. In spite of its emphatic observations, the court did not pass any formal order in the case and accepted the government's assurance. This is also important. The court did not pass any formal order in the case and accepted the government's assurance that Maneka Gandhi would get an adequate opportunity to be heard. The majority upheld the impounding of Maneka Gandhi's passport and held that her passport should remain in the court's custody in the meantime. Justice Beg, who was otherwise part of the majority, did opine that the government order was neither fair nor procedurally proper and deserved to be quashed by the court. Now,
Now,
बोल रहा
no, no,
case
no,
is
no, no,
small.
no. Let us explain the maxim audio alter pattern.
G. So no
Here,
person can be condemned without being given an
hearing.
opportunity of being heard.
Yes. That is violation of natural justice.
Principles of natural justice states that no person can be condemned without being granted an opportunity of being heard.
हाँ.
So the Supreme Court's judgment in Maneka Gandhi has been widely critiqued as one that went out of bounds with reference to the facts before the court. The matter concerned on the face of it, the impounding of an individual's passport, the Attorney General had undertaken that Maneka Gandhi would be provided a post-decisional hearing. Moreover, if the government decided to stand by its impounding order after hearing Maneka Gandhi, it had conceded that the period of impounding would not exceed 6 months from the date of its fresh order. Instead of deciding the case on this finite ground, which means this period would not exceed 6 months from the date of its fresh order. Instead of deciding the case on this finite ground, the court chose to consider several peripheral issues. These issues were pivotal to India's governance, but peripheral in the case. In the judgment that together added up to over 70,000 words. In his candid style, constitutional scholar Arvind Dattar said, there was really no need to write pages after pages on Article 14, 19, 21, and so on. Indeed, why did the Supreme Court say more than what was
एक
needed?
मिनट पढ़ो ना, इधर क्या बोल रहे हो?
हाँ, यहाँ बोल रहा है अरविंद दाता commentary on the Constitution of India with reference, page everything. Then also Sirvai. Sirvai opined that it was not necessary for the Supreme Court to engage in an elaborate discussion on personal liberty, even if the expression were narrowly construed, preventing a person from leaving the country would fall within its ambit. Now he's agreeing in one way and then saying that there was no need for the court to, write pages after pages on 14, 19, 21, and so on. The immediate cause of the court's expansive rights-based approach in Maneka Gandhi was the criticism it faced for its decision during the emergency in ADM Jabalpur case. In fact,
अपने को
Maneka Gandhi,
अपने को ये लोग व्हाइट वॉश कर रहे थे.
Ji. In fact, Maneka Gandhi was followed by a series of actions undertaken by the court and its judges to distance themselves from ADM Jabalpur case. This was akin to an acknowledgement that it had violated the fundamental rights of a large number of people 34 years after the case was decided. They are talking about ADM Jabalpur case. And yet, though the Supreme Court embarked on an inquiry not necessitated by the facts before it in Maneka Gandhi, when we look at it from a result-oriented approach, this is important. When we look at the case from a result-oriented approach, the court's interpretation of Articles 14, 19, and 21 played a hugely beneficial role in shaping India's constitutional policy. That is why this case is cited again and again in other
That's why this
references.
case is very important for every
Ji.
citizen,
So
because it
no
has,
article can be read in isolation.
yes.
These articles ensuring freedom of a person, the right to be heard,
Don't we?
etc. All
Don't you think that we have to discuss about ADM Jalbalpur also sometimes after this?
the ADM Jabalpur is there in my list, sir.
है
The
ना?
list
वो
which I
तो है
have,
आपके पास. हाँ.
that is there in my list. Now, should I read that? I think
नहीं
it's
नहीं,
very short.
बाद में कभी.
ठीक है, ठीक है. Does a law that satisfies all procedural requirements in this enactment, however arbitrary or unreasonable, meet the test of Article 21? This is the question that the Supreme Court sought to answer in Maneka Gandhi by vesting in itself the power of substantive review under Article 21. Because the court has the power of review, by vesting in itself this power of substantive review in Article 21, the court transformed itself from being merely a supervisor to being a watchdog of the Constitution. This is also important. This is the seminal importance of the Maneka Gandhi decision. The key difference between Satwan Singh and Maneka Gandhi,
By vesting in itself the power of substantive
power of
review,
substantive review. So
the
the
court
court has also the
transformed itself from being merely a supervisor
to being a
to being a
watchdog of the
watchdog of
Constitution.
constitution.
So
Constitution.
wherever constitutional rights are hampered, the courts will always step in and ensure that these rights are granted to every citizen. The key difference between Satwan Singh and Maneka Gandhi was that in the former, that means in Satwan Singh's case, the court objected to the restraint on traveling abroad because of the absence of a law. But it did so in the latter, which means in Maneka Gandhi's case, despite the existence of a law. The court's judgment in Maneka Gandhi is based on the simple premise that an arbitrary law is no law. मतलब अचानक वह बंद कर दिया कि नहीं जा सकते हैं बाहर, इनके केस में जो हुआ था, विदाउट गिविंग हर एन अपॉर्चुनिटी ऑफ बीइंग हर्ड. Then I'm reading further. Although the makers of the Constitution rejected the American due process clause, the Supreme Court judgment in Maneka Gandhi effectively meant that procedure established by law under Article 21 would have the same effect as the expression due process of law. Procedure and process would be the same. Due process of law and procedure established by law under Article 21 would mean the same. In a subsequent decision, the Supreme Court stated that Article 21
ये
interpreted
subsequent वाला
according to...
बचन सिंह का केस है, subsequent वाला
हाँ
बचन
हाँ
सिंह.
हाँ हाँ, ये इम्पोर्टेंट केस है ये भी.
The Supreme
In a
Court
subsequent decision, the Supreme Court stated that Article 21 interpreted according to Maneka Gandhi would read as no person shall be deprived of his life or personal liberty except according to fair, just and reasonable procedure established by valid law.
Okay. Fair, just and
Just,
reasonable.
reasonable,
Three
and
ingredients.
valid.
Maneka
Maneka
Gandhi
Gandhi is
is
a
a dynamic constitutional
reflection of the dynamic constitutional interpretation. It signifies the court's changing approach towards the constitution. But this is the first time that the court started changing its approach. Like it was rightly stated before that merely from acting as a supervisor, it became an interpreter of the constitution. It signifies the court's changing approach towards the constitution. In the decades that followed, it was treated as an organic document, which means the constitution. A constitution is an organic document whose interpretation must evolve with the times. With the changing times, the interpretation of the constitution must also evolve. Substantive due process, and more broadly stated, the court's power to review the content of legislation to ascertain if the mandate of Article 21 had been met, eventually found its way to India more than 28 years after the founding fathers of our constitution abandoned it. So earlier it was a bit straight jacketed sort of. Now liberal meaning was given shape in a broader sense. So then some would wonder why there was so much excitement over a verdict that essentially recognized the right of a member of India's most influential political family to go abroad. It is the constitutional developments after Maneka Gandhi that highlight. This is important. It is the constitutional developments after Maneka Gandhi that highlight how it was one of the cases that truly changed in India. For most jurists, it was a turning point in the Supreme Court's interpretation of Article 21. The court moved from a pedantic, which means narrow, to a purposive approach or a purposeful approach in construing the sweep of the right to life under the Constitution. So the right to life was expanded. The judgment became a springboard for the evolution of the law relating to judicial preservation of human rights. Majoritarianism doctrine is something which is straight jacketed. Then majoritarianism would entail a broader interpretation of that broad doctrine, not a pedantic approach, a purposive approach. The most striking aspect of the Supreme Court's introduction of substantive due process was that it empowered courts to expand the limited phraseology of the right to life under the Constitution to include a wide range of unenumerated rights derived from Article 21. These rights cover areas such as the rights of prisoners. इसमें काफी कुछ आ गया फिर. Protection of women and children, environmental rights. Since Maneka Gandhi, courts have included the following rights within the embrace of the right to life and personal liberty under Article 21. The rights of prisoners, including protection from handcuffing without adequate reasons. This is also important because in many cases the courts have stated that there is no reason, if a person has a particular standing in society, then there's no reason to tie a rope around his waist or handcuff him and bring him to court. Access to a transcript of the judgment and facilities to exercise his right to appeal against his conviction, the right to treatment with dignity and humanity, the right of an under trial to be released from custody if the police fail to file a charge sheet within the period prescribed by law. How much this is effective, you know very well, sir. Protection from custodial violence and protection against public hanging. Custodial violence
ना
is
एक
not
मिनट एक मिनट
is
पब्लिक
frowned
बोलती है ना
upon.
कुत्ते के बारे की, ठीक है, कोई किसी ने गड़बड़ किया है तो उसको विजय चौक
बांध
में
के ले आओ उसको.
इंदौर के सामने टांग दो, देख लो
कोई
भाई क्या
पॉसिबल
बोल रहे
नहीं
हैं.
है ना, पॉसिबल नहीं है. तो
नहीं, पब्लिक को मालूम नहीं है ना ये सब कुछ, इसीलिए तो.
देखिए, mere handcuffing also is not recommended. Only in
Environmental rights, right
exceptional
for
cases.
free,
Environmental rights, right to a humane and healthy environment, the right to sustainable development, protection from pollution hazards due to use of pesticides, and the right to live without undue affection of air, water, and the environment. This portion has to be worked upon still. It's in the nascent stages in India. Other rights, including the right to live with human dignity, right including right to nutrition, clothing and shelter, the right to free education of children up to the age of 14 years, the right to livelihood, protection of one's reputation, access to just and humane conditions of work. This is the protection of the health and strength of workers and maternity relief. Now, this is being followed by most reputed companies. Protection of health, strength of workers, and maternity relief, including government institutions. Then
ये
free
जो including
education
the right to live with
with
human
human
dignity की
dignity.
बात कर रहे हैं ना ये.
हाँ
यहाँ पर ये है कि आप किसी को बिना मतलब में उसकी इज्जत नहीं उतार सकते, ये भी है.
जी जी.
जैसे अभी सर्विस में लोग बात करते हैं ना कि यू आर एन इडियट, दिस थिंग एंड दैट थिंग करके वो बंदा
हाँ
आपको
हाँ हाँ हाँ
उठा के डंडा कर सकता है उसके ऊपर.
बिल्कुल सर. Then the lasting impact. Although the Maneka Gandhi judgment permanently clipped the wings of the legislature, it faced little or no hostility from any of the branches of the government, unlike other judgments in the same period. Over 3 decades since the judgment, this is important, over 3 decades since the judgment, the right to life and personal liberty under Article 21 has gradually become a repository of human and fundamental freedoms in India.
मेनका गांधी अगर नहीं होता तो ये बकवास न कर रहे होते, जो बात बात पे जो चिल्लाते रहते हैं ना, वो एक्सप्रेशन की बात करते हैं ना, एक्सप्रेशन को टर्जुमान से भी जोड़ दिया ना. खत्म. अभी और
ये तो दूसरा केस में आ गया हम.
दूसरा पढ़ते हैं, गांगुली साहब का पढ़ते हैं, उसमें क्या लिखते हैं.
जी जी जी.
आज यहीं रहेंगे, मेनका गांधी पे ही रहेंगे हम लोग.
नहीं, इसमें देखिए 3 इंपॉर्टेंट आर्टिकल है, 14, 19, 21, जो हम लोग पहले कवर कर चुके हैं. सो दिस जजमेंट इज वेरी इंपॉर्टेंट बिकॉज दिस इज अ रिफ्लेक्शन ऑफ व्हाट वी हैव बीन डिस्क्राइबिंग अर्लियर और डिस्कसिंग अर्लियर. नाउ व्हाट इज द इम्पैक्ट ऑफ दोस 3 आर्टिकल्स इज वेल represented and reproduced here in this judgment. What it actually means and how it is to be applied.
जिनको नहीं समझ में आता है भाई, अंग्रेजी समझ में नहीं आती है, उसके लिए
the problem is that the problem sir is that since we speak in the courts in English, it's difficult for others to understand. We can comprehend that. लेकिन हिंदी में सर आप थोड़ा.
This system is only for those people who can understand English एंड अपना बाकी पब्लिक को समझाने के लिए आप उसको हिंदी में समझा सकते हो. हम
नहीं, अगर कुछ पूछना हो हिंदी में तो जरूर पूछें सर.
पब्लिक
ये
एट
ओपन
फोरम
टू.
के लिए हम यहाँ पे नहीं बैठे हुए हैं.
नहीं, ठीक है, अगर कोई पूछना चाहते हैं तो दे कैन ऑलवेज आस्क क्वेश्चन.
हाँ, अगर कोई पूछेगा कि हाँ भाई ठीक है इसको हिंदी में समझा दो तो उसको समझा सकते हैं, लेकिन अपने पास कोई सवाल आएगा तभी तो, ऐसा थोड़ा करेंगे.
नहीं, लेकिन एक चीज आप सही बताए कि पब्लिक बोलता है ना, ऐसा कर दो वैसा कर दो, तुरंत पकड़ लो, मार दो, पकड़ लो, बांध कर ले आओ, वैसे नहीं होता है सर. The procedure established by law, but there are certain restrictions. Na? Even the government is restricted from doing so many things.
इसमें है कहाँ पे गया, एक मिनट.
आपका ये भतीजे का वाइफ को तो रोक दिया.
हाँ, आज सुना, मैं मॉर्निंग में न्यूज सुना.
हाँ,
अच्छा है.
लुकआउट नोटिस था. वो दुबई जा रही थी
हम्म.
with her coterie of people. All of them were stopped at the airport.
आई थिंक ये ठीक है, इसको पढ़ो, ये समझ में आएगा पब्लिक को. अगर
जी सर.
मेरे ख्याल में देखो गंगली साहब क्या लिख रहे हैं. आई रिलेवेंट पेज मैंने खोला हुआ है, उसको देखते हैं.
जी जी जी.
आ गया.
जी
फ्रॉम गोपालन टू गांधी.
जी जी. The journey of the Supreme Court from its judgment in A.K. Gopalan versus State of Madras, heard by the Constitution Bench of the Supreme Court in 1950, to the one heard by its Constitution Bench in the case of Maneka Gandhi versus Union of India and others, in which the judgment was rendered in January 1978, is a very engrossing one, covering a span of about 28 years. It shows the swing of the judicial pendulum from the traditional black letter law in Gopalan, which means that pedantic, straight-jacketed approach, to the resurgence and firm assertion of the concept of due process in Maneka Gandhi. This is a dynamic, generic, and more expansive interpretation of fundamental rights. More expansive interpretation of fundamental rights by the Supreme Court in Maneka Gandhi in the post-emergency period not only affected the lives of Indians, but also considerably influenced jurisprudential development in different countries. This judgment was followed by
एक
other
मिनट.
laws.
For the
Yes, sir.
information of the public, this article is from a book written by Justice A.K. Ganguly, Supreme Court Justice, former Justice
He
A.K.
was
Ganguly.
also in Calcutta High Court, and then he was elevated as a judge of the Supreme Court.
2G स्पेक्ट्रम में भी इनका ही केस था, वो इनका
जी
जजमेंट था
जी
ना,
जी
वो ऑर्डर था
जी
जिसमें
जी
कि
जी.
A.K. राजा और कनिमोई सब अंदर गए थे लोग. आगे पढ़ो. डिसीजन.
The decisions in Maneka Gandhi and the allied group of cases are not concerned with constitutional amendments, but they would close a shift paradigm shift in the Supreme Court's interpretation of the basic guarantees given in the Constitution in its chapter on fundamental rights. Fundamental rights have already been discussed in an earlier chapter, the higher laws, to the extent that all laws made by the state after the commencement of the Constitution would have to conform to its mandate, failing which the laws would be declared void. That is Article 13, Sub-Article 2 of the Constitution. Even laws prior to the Constitution can continue only if they are consistent with fundamental rights, and to the extent of their inconsistencies, they are to be declared void. Article 13, Sub-Article 1. Therefore, the changing pattern of interpretation of fundamental rights is integral to our jurisprudence, affecting both the enactment of statutory law and the practice of administrative law. In Gopalan, the validity of the Preventive Detention Act 1950 was challenged mainly on two grounds: whether the act violated the guarantee under Article 21, whether the act fell foul of the freedom guaranteed under Article 19.
Hmm.
One of the questions raised by Gopalan was the procedure provided by the act does not stand the test of procedure established by law under Article 21, and it was argued that the procedure under Article 21 must comply with the principles of natural justice. Chief Justice Kania dismissed the said argument. Yeah, important. He dismissed this argument, saying the courts are not at liberty to declare an act void because, in their opinion, it is opposed to a spirit supposed to pervade the Constitution but not expressed in words. Where the fundamental law has not limited either in terms or by necessary implication the general powers conferred upon the legislature. We
just a minute, just a minute. ये जजमेंट
जी जी
1950 का है ना?
हाँ हाँ हाँ
तो 1950 में कॉन्स्टिट्यूशन इम्प्लीमेंट हो गया था, उसके बाद गोपालन को
हाँ
वो किया।
उसके तुरंत बाद ही ये आया ये रिपोर्टेड 1950 सुप्रीम कोर्ट पेज 27
तो दैट मीन दैट टाइम अंबेडकर साहब वुड हैव बीन अलाइव ना,
डेफिनेटली
तो इसीलिए कानिया साहब की हिम्मत नहीं हुई।
हाँ सो बोले कि जैसा है वैसे ही रहने दें वी विल नॉट इंटरफेयर विद दिस
हाँ वही ना, ये
प्रोविजंस
सारे के सारे जो कॉन्स्टिट्यूशनल के जो बनाने वाले होंगे ये 1978 में चले गए होंगे ना, इसलिए जनवरी 78 में ये जजमेंट आया।
बिल्कुल सर तो
they would have been respecting the founder, the framer अपना डॉक्टर राजेंद्र
जी
प्रसाद
जी
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 थे,
जी
वो
जी जी
प्रेसिडेंट ऑफ द कॉन्स्टिट्यूशन असेंबली, अंबेडकर भी थे, के मुंशी भी थे, सारे सारे तो थे, जवाहरलाल नेहरू
हाँ
थे
तो
ही थे। उन्होंने बोला साला
हाँ
आप
तो
बेवकूफ है क्या, तुम्हारे बना के बैठे हुए।
नहीं छेड़छाड़ करना पसंद भी नहीं किए इसीलिए
हाँ
because that weighed heavily on them na? the
यस
presence of those luminaries the presence of those luminaries weighed heavily in the conscience of the court so they chose not to interfere
यस कि इन लोगों ने इतने दिन तक मेहनत किया, 2-2.5 साल तक के लिए,
हाँ
हम लोग इसको उड़ा के
ए, ए,
फेंक देंगे तो ये हमको गाली देंगे, या फिर
गाली
कोई
नहीं
गड़बड़ कर
बुरा
देंगे, पुलिस
लगेगा
की गुत्ती साहब हटो भागो यहाँ जाओ।
जी जी जी
We cannot declare a limitation on the notion of having
limitation and notion of having discovered देखिए having discovered something in the spirit of the constitution which they later did they did discover the something in the spirit of the constitution
hmm,
subsequently in Maneka Gandhi which is
hmm.
not even mentioned in the instrument meaning the constitution the court by laying down the aforesaid proposition refused to examine देखिए सर क्या है उसमें हाँ फुट नोट यार हाँ पेज
उसी
बता
बात
ना मैं यार 1950 मेरे पास है लिखा हुआ है पेज 27 the court by laying down the aforesaid proposition refused to examine whether the procedure was fair as the word due is absent in article 21 and the learned chief justice held that the justiciable aspect of the law that is what is that to consider whether it is reasonable or not by the court does not form part of the Indian constitution यहाँ देखिए हाथ धो रहा है साफ
Eh,
they are washing their hands off. Therefore, the learned Chief Justice opined that the Constitution gave the legislature the final word to determine the law, which now people are disagreeing. देखिए, even अभी भी
नहीं
चंद्रचूड़
तो
साहब
चंद्रचूड़ साहब को पढ़ना चाहिए ना, जस्टिस कानिया साहब
ये
गलत बोल
पढ़ना
रहे
चाहिए
थे।
हाँ हाँ यही मैं सोच रहा था पढ़कर On the second question, namely on the interrelationship between Articles 19 and 21, all the judges, excepting Justice Fazl Ali, held that the Articles 19 and 21 had to be read as mutually exclusive. It was held by the
क्यों?
majority that देखिए म्यूचुअली एक्सक्लूसिव को बाद में जोड़ दिया सब बाद में in Maneka Gandhi it was held by the majority that articles 19 and 21 are not complementary to each other as there is no mention of the right to life in article 19
जस्ट
however the
जस्ट
dissenting
जस्ट क्या है ये, राइट टू लाइफ नहीं है? अच्छा
ने उस समय का व्यू यही था बट dissenting judge however the dissenting view expressed by justice Fazl Ali demonstrate, demonstrates judicial thinking which is much ahead of his time the learned judge in his dissent held
फजल अली ने बोला कि हाँ होना चाहिए। To my mind, the scheme of the chapter dealing with the fundamental right does not contemplate what is attributed to it, namely that each article is a code by itself and is independent of others. In my opinion, it cannot
It
be
cannot
said.
be said.
Hmm.
डू नॉट टू सम एक्सटेंट, देखिए ये प्रिंसिपल बाद में फॉलो किया गया ना, आर्टिकल्स 19, 20, 21 एंड 22, डू नॉट टू सम एक्सटेंट overlap each other. That means to some extent they overlap each other. If we read it in another way, so they do to some extent overlap each other. Some extent use कर रहा ना ये word जो बाद में लिया गया. So he was
इन लोगों
ahead
को
of his times.
जजेस की सीट पे बैठ करके इनका दिमाग जो है ना लॉक हो जाता है, लगता है कहीं ना कहीं सिक्योरिटी लॉक लग जाता है इनको. क्या बात है. They do overlap.
Definitely, later on it was proved that they do overlap, but at that time he said do not to some extent, but he gave some leverage. But he was a dissenting judge. He gave some leverage, do not to some extent overlap. Some extent word use कर रहा है.
आगे पढ़ो.
As in other cases discussed in the previous chapter, in this case also the dissenting opinion was subsequently accepted by the Supreme Court. This was done in Rassamji Kawasji Cooper versus Union of India, hereinafter referred to as the Cooper's case, which is referred to later. On 11th of January 1952, within a year and a half of the decision rendered in Gopalan's case, the Constitution Bench of the Supreme Court, this time consisting of 7 judges in the state of West Bengal versus Anwar Ali Sarkar, examined the virus of the West Bengal Special Courts Act 1950, and the Constitution Bench held that the provision of Section 5, subsection 1 is ultra virus to the Constitution insofar as it allows the state government to direct any case to be tried by a special court. अभी तो सब स्पेशल कोर्ट चल रहा है. Now this has gone. While agreeing with the majority opinion and defining what is meant by classification, Justice Vivian Bose virtually leaned in favor of an interpretation which amounted to introducing the due process principle. While determining whether a classification was valid or not, the learned judge held, however much the real ground of decision may be hidden behind a screen of words like reasonable, substantial, rational, and arbitrary, the fact would remain that judges are substituting their own judgment of what is right and proper and reasonable and just for that of the legislature. At least he had the courage to write this. And up to a point, that I think is inevitable when a judge is called to crystallize a vague generality like Article 14 into a concrete concept.
Good.
There's a web of words. There's a web of words here, interwoven, but the meaning is clear for us. यहाँ थोड़ा सा ये बोले हैं कि the judge cannot, impose something which in his opinion he considers right, proper, just, reasonable for that of the legislature up to a point which I think is inevitable. So judge is called in to crystallize a vague generality into a concrete concept. अब आप बोले थे ना कि यहाँ के लोग जो है ऐसा अंग्रेजी लिखते हैं कि जनरल पब्लिक समझ नहीं पाएगा क्या है. ये बात आप बोले थे.
कल मैं उसका इंटरव्यू सुन रहा था. तरूर का डैडी जो है वो स्टेट्समैन में जर्नलिस्ट था.
अच्छा, इसीलिए वो मतलब अपना वोकैबुलरी इतना बड़ा है.
बेस्ड इन बॉम्बे, तो मॉर्निंग में वो स्टेटमेंट पढ़ता था, शाम के टाइम में बाकी जितने भी पेपर थे वो हवाई जहाज से आते उनको पढ़ता था वो. That's why his English is like that.
नहीं सर, एक जमाने में स्टेट्समैन वाज द पेपर recommended by every school कि जितना भी डिफिकल्ट हो, you sit with the dictionary, read the statesman, and improve your vocabulary.
Yes.
This is a stark contrast.
जितने भी जजेस बनते होंगे स्टेट्समैन पढ़ते होंगे.
सर मैं भी पढ़ा हूँ सर, झूठ क्यों बोलूं, मैं भी पढ़ा हूँ.
बहुत 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 तगड़ी अंग्रेजी है भाई उसकी, बहुत.
नहीं लेकिन देखिए सर, एक बार पढ़ने से दिमाग में बैठ जाता है, ऐसा बात नहीं है. आप भी तो पढ़ रहे हैं सर, आप भी तो पढ़े आज, अभी भी तो पढ़ते हैं आप. तो
वही बोल रहा हूँ ना, इंग्लिश इंप्रूव करने के लिए मैं तो इसीलिए अप्रिशिएट करता हूँ ना उसको बहुत. अगर आपको अंग्रेजी की वोकैबुलरी अच्छी करनी है तो इट इज मस्ट। अब पता नहीं
लेकिन
कैसा
भले,
स्टैंडर्ड है, आपको पढ़ने को नहीं मिलता।
नहीं नहीं, नहीं नहीं, ये आपका, ये इनका न्यूज जो है गलत है, इट्स बायस्ड, आई एग्री, इट्स बायस्ड, बट इफ यू just read it for the sake of improving a vocabulary, then it's okay. This is in stark contrast to the interpretation of Justice Kani and Gopalan about a year and a half ago. नहीं, उसमें अंग्रेजी ठीक था जब तक नॉरिस लिंडसे एमर्सन करके एक थे उनके एडिटर, उस समय तक अंग्रेजी बहुत बढ़िया था। उसके बाद फिर थोड़ा खराब होने लगा, मतलब उतना स्टैंडर्ड बढ़िया नहीं है, लेकिन फिर भी कंपेयर टू अदर पेपर्स इट्स स्टिल बेटर, बट इट्स वेरी बायस्ड, दैट्स व्हाई आई स्टॉप टेकिंग दैट पेपर. And it may be mentioned that the three learned judges, M.C. Mahajan, B.K. Mukherjee, and S.R. Das, who shared the views of Justice Kani and Gopalan, were also members of the bench of Anwar Ali. Justice Bose gave the aforesaid interpretation. As his lordship thought, if I may say so rightly, that the words of the Constitution are not dull, lifeless, and static words, as in some mummified manuscript. ये कोट अनकोट कर रहे हैं, मतलब उनका ये जजमेंट में ये लैंग्वेज रहा होगा, एज इन सम ममीफाइड मैन्युस्क्रिप्ट. According to Justice Bose, they are living flames and tongues of dynamic fire, potent enough to mold the future as well as guide the present. The learned judge rightly understood the basic tenets of constitutional interpretation by holding the Constitution must, in my judgment, be left elastic enough to meet from time to time the altering conditions of a changing world.
गुड।
Very good, sir. With its shifting emphasis and differing needs. This holds true always. Every constitution must be like this. It must be altered according to the needs of the times.
हाँ, कान्या साहब बेवकूफ थे, वो तो ये बोल सकते हैं।
बेवकूफ नहीं, he wanted to, I mean, क्या बोलो, toe in the line sort of.
मैं बेवकूफ थोड़ा सा केयरफुली यूज कर रहा हूँ, मैं कुछ और भी घटिया वर्ड यूज कर सकता था। ही वाज पट्टू, उसको डरता था कि अम्बेडकर
क्या
साहब और
जरूरत है, छेड़छाड़ नहीं करूंगा. Thus it is clear that the germs of future
बोस
jurisprudential
के टाइम में तो वही
interpretation.
थे,
जी जी,
बोस के टाइम में तो वही एस्टेब्लिशमेंट था।
हाँ हाँ, नहीं
तो
था,
बोस
लेकिन some judges are like this ना, they like to leave an impact in their judgments so that generations later people will remember them. ये भी एक बात है
कान्या कहीं पारसी तो नहीं था?
सर, ये तो बड़ा बताना मुश्किल है क्योंकि टाइटल से पता नहीं चलता है.
उसका नाम पूरा पढ़ेगा
बस,
तो मालूम पड़ेगा कि आपको कहीं पर होगा
जी
ना,
जी
अगर
जी
वो फिरोज शाह टाइप होगा तो हो सकता है।
जी जी. Thus, it is clear that the germs of future jurisprudential interpretations of fundamental rights were there in the judgment of Justice Bose as early as in January 1952. देखिए, 2 साल के अंदर. However, the Gopalan doctrine was not overruled in Anwar Ali. The majority ratio in Gopalan held the field till it was examined and overruled by the majority judgment of the Supreme Court, the 11 judge decision in Cooper's case. Now, let's see what the Cooper's case is. Cooper held shares in several banks and also had bank accounts. He was also a director of the Central Bank of India. Before the Supreme Court, he challenged the banking company's acquisition, ये जो हम लोग करते हैं ना, and transfer of undertakings ordinance, and the banking company's acquisition and transfer of undertakings act 1969, which replaced the ordinance. Cooper also challenged the promulgation of another ordinance on the same day, that is 19th of July 1969, whereby the
ये
undertaking,
इंदिरा हैज
हाँ हाँ हाँ
बैंक्स एंड
हाँ हाँ, nationalization of banks.
देसाई एज फाइनेंस मिनिस्टर, वो उसका है वो।
नहीं, पहले तो सर ये एक्ट पूरा लिखा रहता था ना, this is an institution formulated under the Banking Companies Acquisition and Transfer of Undertakings Act, ये लिखना पड़ता था फर्स्ट टाइटल में भी.
हाँ हाँ हाँ,
Whereby the undertaking of 14 named commercial banks were transferred and vested under the ordinance in the government. Apart from the other questions, the challenge on which the constitutional interpretation of fundamental rights by the Supreme Court change from where it rested in Gopalan was in examining the petitioner's challenge that the impugned enactments violated his fundamental rights under Article 14, 19, sub-article 1F and G, and Article 31, sub-article 2 of the Constitution. A challenge was also made to the invasion of his right under Article 301. In upholding the said challenge, Justice Shah, delivering the majority judgment, held that Articles 19(1)(f) and 31(2) were not mutually exclusive. Before reaching the said conclusion, were not mutually exclusive. Before reaching the said conclusion, the learned judge dealt in detail with Gopalan and various other cases, namely the case of Ram Singh and others versus State of Delhi, and the ratio in Gopalan was expressly departed from. Ratio of Gopalan was expressly departed from.
In RC Cooper.
In RC Cooper, in para 49, the learned judge summed up the ratio in Cooper's case, saying, in determining the impact of state action upon constitutional guarantees, which are fundamental, it follows that the extent of protection against the impairment of a fundamental right is determined not by the object of the legislature, nor by the form of action. हम लोग बोलते हैं ना, the object of the legislature, कोई act खोलते हैं, we read what was the object of the legislature, lordship kindly sees करके हम लोग बोलते हैं. So here is saying that it follows that the extent of protection against the impairment of a fundamental right is determined not by the object of the legislature, nor by the form of the action, but by its direct operation upon the individual rights.
Wow.
Individuals' rights.
ये citation है यार.
हाँ. Supreme Court cases, 1970, volume 1, पेज 248, पैरा 49, और पेज 248 से शुरू है, 228 का ये रेफरेंस है. Thus, the object test in Gopalan was replaced in Cooper's case by the effects test. What is the effect? The overall effect of the matter. In fact, referring to various articles in Part 3 of the Constitution, the learned judge said that they do not follow a uniform pattern, but according to the learned judge, there was a common thread running through them, namely the protection of rights of individuals or groups of individuals against infringement by state action. That is why the learned judge held that Part 3 of the Constitution weaves a pattern of guarantees on the texture of basic human rights. The guarantees delimit the protection of those rights in their allotted fields. They do not attempt to enunciate distinct rights. So distinction khatam kar diya fir. They do not attempt to enunciate distinct rights. Subsequently, 2 constitutional bench decisions of the Supreme Court, delivered within a gap of about 4.5 years, expanded the ambit and reach of the court's interpretation of fundamental rights and were in favor of protecting those rights which were facing invasion by the state authority. मतलब बात पे जो state interfere करेगी, there will be a narrow interpretation. The first was delivered before the emergency in the case of E.P. Royappa versus State of Tamil Nadu, while the second was delivered after the emergency in the case of Maneka Gandhi.
The sense of freedom was dawning on the judges, like ऐसा लगता है मेरे को.
हाँ, धीरे-धीरे, gradually, but the time span was quite short.
Yes.
After a gap of 4.5 years, 4.5 years is still a short period of time after 1950.
E.P. Royappa is citation is this. Please note if somebody wants. 1974.
74.
3.
Volume 4, Supreme Court cases, page 3.
While the second was this, 78. Okay.
इसका तो citation मिल जाएगा.
वो तो
this is 1978 SC 597. ये अपना मानेका गांधी. 1978 SC 597.
इसमें देखते हैं चंद्रचूड़
E-
के पिताजी क्या बोलते हैं, थोड़ा देखें इसको।
E.P. Royappa, who held the post of Chief Secretary in the government of Tamil Nadu, was transferred to a newly created post of a temporary nature, and he challenged the said transfer in Article 32 petition on the ground that he had been denigrated to a relatively unimportant post, as he had incurred the displeasure of the Chief Minister of the state. The Supreme Court, while dismissing the petition, gave a new interpretation to Article 14, which was further developed in the subsequent decision in Maneka Gandhi. Justice Bhagwati, while delivering a concurring opinion with Chief Justice Ray, relied on the concept of reasonableness, hitherto unknown in the arena of Article 14. Justice Bhagwati raised a question on the content and reach of Article 14 and then answered it in very glowing terms. It is a founding faith, to use the words of Bose, a way of life, and it must not be subjected to a narrow pedantic or lexicographic approach. सिर्फ लैंग्वेज का ही अप्रोच होना नहीं चाहिए. We cannot countenance any attempt to truncate, cut down all its embracing scope. It's all embracing scope and meaning. For to do so would be to violate its activist magnitude. बाप रे. Equality is a dynamic concept with many aspects and dimensions, and it cannot be cribbed, which means cut, cabined, confined, and confined. Cabined and confined is the same thing within traditional and doctrinaire limits. From a positivistic point of view, equality is antithetic to arbitrariness. In fact, equality and arbitrariness are sworn enemies. One belongs to the rule of law in a republic, while the other to the whim and caprice of an absolute monarch. When an act is arbitrary, it is that i- implicit in it that it is unequal both according to political logic and constitutional law, and is therefore violative of Article 14.
बाप रे, क्या लैंग्वेज है भाई.
लेकिन सर इसी के ऊपर बेस करके केस जो है मतलब फॉर्मुलेट किया जाता है. while drafting a petition also these things have to be kept in mind. नहीं तो पकड़ेगा यहीं फंस जाएंगे ना हम लोग.
This is a must for all law student at least.
Definitely. The expression "a way of life" was used by Justice Bose in his concurring opinion in the case of BD Supply Company versus Union of India and others. While interpreting Article 14, Justice Bose referred to certain other important ideas in the point. Article 14 sets out, to my mind, an attitude of mind, a way of life, rather than precise rule of law. It embodies a general awareness. या ये भगवत गीता का डेफिनेशन दे रहा है क्या?
Justice Bose says that Article 14
Is an attitude of
way of life,
mind, way of life, rather than a
not
precise
rule of
rule of
law.
law. It embodies a general awareness in the consciousness of people at large of something that exists and which is very well and which cannot be pinned down to any precise analysis of facts.
क्या बात है.
Justice Bhagwati virtually enlarged the embryo of the said concept in extremely elegant prose, and in the process was inspired by the Shakespearean turn in the phrase in Macbeth. क्या लिख रहे हैं सर? देखिए 21 में क्या शेक्सपियरियन phrase है of Macbeth. Let's see. Shakespeare used the expression in a slightly different order. Cabined, cribbed, and acha, confined. Spoken in Macbeth Act 3, Scene 4 of Macbeth.
वही भगवती साहब लिख रहे हैं ना उसको.
In doing so, Justice Bhagwati, in his opinion, broadened the sweep of Article 14 by taking it beyond the doctrine of classification based on an intelligible differential with a nexus between the basis of classification and the object of law under consideration as laid down by Chief Justice S.R. Das in Sri Ramakrishna Dalmia versus Sri Justice S.R. Tendulkar and others. रामकृष्ण डालमिया इनके ऊपर केस कर दिया था. जस्टिस एस.आर. तेंदुलकर and others.
मेरे ख्याल में the mood of the judges in 60s and 70s was very much volatile. They wanted to be free from the clutches of the British rule. और
legislature
इसलिए ये लोग
and other state organs.
काफी कुछ पढ़ते लिखते थे, लिटरेचर भी पढ़ते रहे होंगे, सो दैट इट बिकम्स लाइक क्या बोलते हैं माइलस्टोन फॉर द कमिंग जनरेशंस. इसलिए अच्छा इतना अच्छा मतलब जजमेंट लिखते थे वो.
Develop किया, law develop किया,
हम्म.
the interpretation of law. However, one thing of some interest is that in a matter of less importance, देखिए यहाँ लिख रहा, however one thing of some interest is that in a matter of less importance, जो केस हम लोग पढ़ रहे थे, that
हाँ वो
gentleman said that I'm being transferred because the chief I mean minister is not happy with me, our chief secretary, which is not punishment in service law. ये तो अपने को मालूम है सर. Transfer is an incidence of service. We cannot challenge it. Correct, sir? Transfer is an incidence of service under administrative, I mean, क्या बोलूं मैं, under administrative exigencies.
है ना कि ठीक है अगर you are required somewhere
Exigencies.
हाँ.
Justice Bhagwati propounded the aforesaid doctrine in Article 14 by holding that equality is antithetic to arbitrariness and they are sworn enemies, but when questions of a far greater import relating to deprivation of personal liberty and a citizen's access to a court of justice came up before him later in ADM Jabalpur versus S.S. Shukla, Justice Bhagwati did not take the aforesaid view, which was actually put forward by Justice Khanna in his lone dissenting voice. However, it has already been noted that several decades before, Justice Vivian Bose, in his opinion in Anwar Ali, rejected the narrow doctrinaire approach to Article 14 as pointed out. However, this doctrine of reasonableness and non-arbitrariness emerged with much greater force in Maneka Gandhi versus Union of India and others.
इसको दोबारा पढ़ो. पीएन भगवती को क्या सांप सूंघ गया था क्या जब एडीएम जबलपुर का जजमेंट दिया? तो
मुझे तो लग रहा है यही ना.
नहीं वो डर गया होगा इमरजेंसी के टाइम में. कहीं ऐसा ना कि हमारे को भी या तो he would have been interested in becoming chief justice, never to antagonize the government. He would have not started.
He did not take that earlier view, no.
हाँ, इंदिरा जी हार जाएंगी इसने कभी सोचा नहीं होगा. उसको लगा इंदिरा जी अब हमेशा रहेंगी.
So then the public must understand that we approach the courts with certain principles of law in mind and judgments in support. But necessarily the judges, in their own wisdom, may not interpret the law according to our presentations.
नहीं, मेरा कहने का मतलब ये है कि टू कंट्रास्टिंग व्यूज आर कमिंग ऑफ पीएन भगवती ना.
इसमें तो यही आ रहा ना.
एक जगह और कुछ बोल रहे हो. वो एक ही आदमी
एक ही आदमी दो केस
और वो डिफरेंट दो केसेस में डिफरेंट जजमेंट देता है. इसका मतलब ये हुआ कि ही इज नॉट स्टैटिक इन हिज थॉट.
करेक्ट.
वो मैटर ऑफ कन्वीनियंस की बात करता है कि मेरे लिए क्या अच्छा रहेगा, ये सोचता है वो.
बिल्कुल सर, बिल्कुल. Right, sir. However, it has already been noted that several decades before, Justice Vivian Bose, in his opinion, rejected the Maneka Gandhi, presently Union Minister for Women and Child Development, was noticed by the Regional Passport Authority to the effect that a passport had been impounded and she was asked to surrender the same within 7 days. This straight away एक order pass हो गया. Without calling, without giving her any opportunity. So she filed a petition under Article 32 before the Supreme Court, and the contentions raised by her were, the chief among them was that the right to go abroad is a component of the right to life and personal liberty under Article 21. She was denied the said right without a hearing and without any reason for such denial. Section 10, subsection 3C of the Passports Act 1967 empowers the Passport Authority to impound a passport in the interest of the general public was vague and unreasonable. इनका मतलब वो stand यही था. The Supreme Court held that that section is not violative of Article 14, but the order of, देखिए, on one hand it's saying that it's not violative of Article 14, but on the other hand it's saying that the order of impounding was in violation of the principles of natural justice, which means she was not afforded an opportunity of being heard before her passport was impounded. Since the Attorney General assured the court of expeditious consideration of any representation that may be made by Mrs. Gandhi, the court felt that the vice should be removed and the order could not be assailed on the ground that it violated the principles of natural justice. In doing so, the court relied on the concept of post decisional hearing, curing the defects in an earlier order which had been passed without a hearing. In the opinion of Chief Justice M. Hamidullah Beg in Maneka Gandhi, there was tacit approval of the dissenting opinion of Justice Khanna in ADM Jabalpur, even though Chief Justice Beg had not agreed with Justice Khanna in ADM Jabalpur. But in Maneka Gandhi, Chief Justice Beg clearly stated, I
अब
think
क्यों?
that both.
अब क्यों?
हाँ
हाँ,
तो वही तो मैं बोल रहा हूँ,
ये सब ऐसे ही है ना, एक हवा कैसी चलती है उसके तरीके से बहती
कंसिस्टेंसी
है।
नहीं है. The same judgment given by him is not relied upon in another judgment. But in Maneka Gandhi, Chief Justice Beg clearly stated, I think that both the rights of personal security and of personal liberty recognized by what Blackstone termed natural law, ये डिक्शनरी पे चला गया Blackstone legal lexicon, are embodied within Article 21 of the Constitution. Thus, the learned Chief Justice also relied on the majority doctrine in the case of I.C. Golaknath versus State of Punjab that fundamental rights are natural rights embodied in the Constitution itself. Chief Justice Beg, after quoting the dissenting view of Justice Fazl Ali in Gopalan, seems to have agreed with the said dissenting view, saying articles dealing with the different fundamental rights contained in Part 3 of the Constitution do not represent entirely separate streams of rights which do not mingle at many points. They are all parts of an integrated scheme in the Constitution. That means 14 से लेकर 21 तक. Their waters must mix to constitute that grand flow of unimpeded and impartial justice. Expanding his doctrine, Royappa Justice Bhagwati in Maneka Gandhi held that the attempt of the court should be to expand the reach and ambit of fundamental rights rather than attenuate their meaning and content by a process of judicial construction. His Lordship also held that Article 14 pervades like a brooding omnipresence, and the procedure contemplated by Article 21 must answer the test of reasonableness and must be in conformity with Article 14. His Lordship further held that it should be right, just and fair, and not arbitrary, fanciful, or oppressive. सर मैं एक सेकंड में आ रहा हूँ सर.
हाँ ठीक है. This refreshingly right-oriented approach of Justice Bhagwati was quite contrary to his view in ADM Jabalpur. However, the matter which is of great importance is that for the first time in the constitutional history of India, a majority judgment of Supreme Court acknowledged that the right to life and personal liberty must stand the test of fairness and reasonableness. Even though the principle of due process was explicitly deleted from our constitution by the founding father, however, there is a substantial difference between the doctrine of reasonableness articulated in Khanna's dissent in ADM Jabalpur and the one formulated by the majority opinion of Justice Bhagwati in Maneka Gandhi. In ADM Jabalpur, Justice Khanna rested his doctrine on the concept of natural law, but in Maneka Gandhi, Justice Bhagwati rested his doctrine on the text of the Constitution itself, Article 14, by employing a protean and flexible interpretation of fundamental right under our Constitution, and doing so, Justice Bhagwati endorsed the interpretation of fundamental right in Cooper case. अब ये सारे के सारे नोट हैं जो ऊपर लिखे गए हैं.
रेफरेंसेस हैं.
ठीक है भाई, ये तो छोड़ दो, जाने दो. फिनिश फिनिश मेनका गांधी फिनिश. इसके पीछे क्या है? ये क्या बोल रहे हैं यहाँ पे? इसमें एडीएम जबलपुर है क्या? अरे पढ़ना जरूरी है. ओके, वो 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 क्या है ये? केशवानंद भारती है क्या ये? ड्यू प्रोसेस डॉक्ट्रिन. हाँ ये है ना एडीएम जबलपुर. 9 मिनट बाकी है, पढ़ सकते हो? फ्री हो? मैं पढ़ू? Upholding individual liberty and opposing the state encroachment of the same during the emergency. ADM Jabalpur versus Shukan Sukla, etc., etc. ये जजमेंट है, देख लो, 1976 का जजमेंट है, ड्यूरिंग इमरजेंसी, सुप्रीम कोर्ट केसेस 1976 वॉल्यूम 2 पेज नंबर 521.
Upholding individual liberty and opposing the state's encroachment of the same during the emergency.
The importance of this judgment lies in its
मैं
monumental
पढ़ूं
dissent.
सर? The importance of this judgment lies in the monumental dissent by Justice Hansraj Khanna, in which the learned judge, during the dark days of that phony emergency, kept the flickering candle of individual liberty burning. This minority judgment also paved the way for the future development of the due process doctrine in Maneka Gandhi versus Union of India and others, which rests on the concept that anything arbitrary is an antithesis of the guarantee of equality in Article 14. The judgment also resulted in a far-reaching constitutional amendment by the Constitution 44th Amendment Act 1978, by which it was made clear that proceedings for enforcement of rights under Articles 20 and 21 of the Constitution, even during an emergency, can never be
Suspended.
suspended by a presidential declaration under Article 359 of the Constitution. The decision arose in the background of the following facts. Various persons who were detained under Section 3(1) of the MESA, Maintenance of Internal Security Act, petitioned before different high courts for habeas corpus, meaning for production, because it was not known where they are being held, praying for their release. At the hearing of those petitions, the state governments raised the preliminary objection to their maintainability on the ground that the plea for release of their detainees, being substantially based under Article 21, could not be entertained by the high courts, as the the rights of the petitioners to move any court for enforcement of freedom under Article 21 had been suspended by the presidential order dated 27th of June 1975, issued under Article 359 as a sequel to the emergency declared in the country. Therefore, the state governments and various high courts contended that the petitions should be dismissed at the threshold. अब देखते हैं. The high courts of Allahabad, Bombay, Delhi, Karnataka, Madhya Pradesh, Punjab, and Rajasthan held that it was open to the detainees to challenge the detention if they could show the same was ultra virus under MESA, or that the power of detention had been exercised in breach of the conditions prescribed in the Act. However, the High Courts of Andhra Pradesh, Kerala, and Madras upheld the preliminary objection. मतलब ये तीन कोर्ट जो है स्ट्रेट अवे राजी हो गए कि सही है. Various state governments and the Union of India challenged before the Supreme Court the orders of the High Courts, which overruled the preliminary objection of the government. During the pendency of the proceeding before the Supreme Court, the President issued a further order on 8th of January 1976, under Article 359, Sub-Article 1 of the Constitution, declaring the right to move any court for enforcement of rights under Article 19.
क्या तमाशा था यार.
And any proceeding pending in any court for the enforcement of those rights, क्योंकि ये सब केस था ना, would remain suspended during the proclamation of emergency dated 3rd of December 1971 and 27th of June 1975. The case was heard by a constitution bench of the Supreme Court consisting of Justice A.N. Rai. कौन थे? Justices H.R. Khanna, M. Hamidullah, then Hamidullah Beg, Y.V. Chandrachud, and P.N. Bhagwati. 5 judgments were delivered by all the 5 judges separately, but the majority opinion of Chief Justice A.N. Ray, Justice M.H. Beg, Justice Y.V. Chandrachud, and Justice P.N. Bhagwati upheld the preliminary objection of the government. यहाँ देखिए सर, they all upheld.
नहीं, इसके आगे वाला पेज बहुत इंटरेस्टिंग है यार. देखो,
जी जी जी
एयर
जी।
रे was chief justice.
एन रे।
Beg
अच्छा,
became
ये भी
chief
देखिए।
justice. YV
हाँ,
Chandrachud became
वाई
chief
वी
justice.
चंद्रचूड़ बिकेम
Bhavati
चीफ,
became chief justice.
पीएन
आपको
भगवती
समझ में आ
ऑल्सो
रहा है?
बिकेम अ चीफ जस्टिस। तो
मैं
टू
यहाँ पर
अपीज द
ये कहना चाह रहा हूँ कि दिस इज द क्रक्स ऑफ कॉलेजियल सिस्टम, क्योंकि उस समय जो गवर्नमेंट की चमचागिरी करता था उसको चीफ जैसे बनाते थे।
बिल्कुल बिल्कुल सर।
अब आगे देखो चार
That
खन्ना का क्या हालत किया इन लोगों ने।
and held that in view of the presidential order dated 27th of June 1975, no person had the right to move a writ petition under Article 226 before a High Court for habeas corpus or any other writ to challenge the legality of the detention order on the ground that the order is not under or in accordance with the Act, or is illegal, or is vitiated by malafidis, factual and legal, or is based on extraneous consideration. Jestice
अच्छा,
Khanna
एक
in
मिनट
his
में आपसे
dissent.
एक बात
जी
डिस्कस
जी
करना
जी
चाहता हूँ
जी सर।
कि when they were detained that time this stipulation that they cannot be challenged in any court of
नहीं, ये
law,
तो बाद में,
that came
बाद में
afterwards,
हुआ
no?
ना। ये तो
That came
बाद में हुआ
afterwards,
ना।
मतलब पीछे से उसको लागू कर दिया था,
हाँ।
मतलब उसको रेट्रोस्पेक्टिव नहीं प्रोस्पेक्टिव दे दिया था क्या, क्या कैसे किया, रेट्रोस्पेक्टिव दे दिया था?
नहीं, रेट्रोस्पेक्टिव तो चैलेंज का था, फिर प्रेसिडेंशियल और एक अमेंडमेंट हुआ ना कि ये जितने पिटिशंस फाइल किए गए इसको आगे भी लाया नहीं, मतलब आगे लेकर आप जा भी नहीं सकते।
ओके ओके ओके, अच्छा।
उनके चलते ये लोग डर गए। अब क्या हुआ मालूम नहीं है। क्या बोलूं मैं, डर गए तो बोल नहीं सकता हूँ मैं। In their wisdom, they thought, no, let us not proceed and write all this. Legality of the detention order on the ground that the order is not under or in accordance with the act or is illegal. Not accordance with the act.
I was detained that time, that law was not existing, मैं उसकी बात कर रहा हूँ।
हाँ, तो बोल रहा हूँ सर, 2 बार तो फिर वो मतलब अपना डिसीजन चेंज किए ना।
जैसे खन्ना पढ़ो आगे, हाँ क्या?
In the dissenting opinion held inter alia that Article 226 empowering the High Court to issue writs of habeas corpus was an integral part of the Constitution. That is correct.
And
Constitution,
no power had
and
been
no
conferred, हाँ
power had been
that's what
conferred by the Constitution on any authority.
हाँ,
This is important. He has
आजकल
rightly
इसको
put,
यही पढ़ाया जाता है।
no power had been conferred. आप जितना भी ordinance निकालें, जो भी करें, no power had been conferred by the Constitution on any authority for suspending the power of the High Court to issue a writ in the nature of habeas corpus during emergency.
You can
Because
interfere
that's
in executive matter, but you cannot interfere in judicial matter, ना?
जुडिशियल मैटर। हाँ, तो देखिए सर, ये आंसर यहाँ फिर और क्लियर हो रहा है। हिज लॉर्डशिप फर्दर हेल्ड दैट अ प्रेसिडेंशियल ऑर्डर अंडर आर्टिकल 359 सब आर्टिकल 1 one could suspend during emergency the right to move any court for the for the enforcement of fundamental rights mentioned in the order, but at the same time rights under statute, देखिए, this is the important part, but rights under statute not being not fundamental rights could be enforced during the emergency despite the presidential order. His lordship also held that Article 21 could not be considered to be the sole repository of the right to life and personal liberty. Even without Article 21, the state does not have the power to deprive a person of his life and liberty without the authority of law, as the same is a basic postulate and assumption of the rule of law in every civilized society. His lordship further explained that even before the constitution came, no one could be deprived of his life or liberty without the authority of law. Such a legal position continued in force after the commencement of the Constitution in view of Article 372. We find these thoughts in an embryonic form in the opinion of Justice Khanna and Keshavananda Bharati as well. Justice Khanna held it in this case, Keshavananda Bharati case. It would, in my opinion, not be a correct approach to say that amendments of the Constitution relating to abridgment or taking away of fundamental rights would not have the effect of denuding human beings of basic dignity and would result in the extinguishment of essential values of life. Therefore, His Lordship upheld the views taken by the 9 High Courts that the presidential order dated 27th of June 1975 could not affect the maintainability of a habeas corpus petition. That order sought to, restrict the High Courts from entertaining any petition. His Lordship now, however, did not pronounce on the validity of Section 16A, subsection 9 of MISA, since the habeas corpus petitions were pending a decision on merits before the High Courts. About the majority judgment, Chief Justice M.N. Venkatachalaya, in his H.R. Khanna Memorial Lecture delivered in New Delhi on 25th of February 2009, opined that it should be confined to the dustbin of history. The learned Chief Justice equated the dissent of Justice Khanna with that of Lord Atkins in Lever Sidge versus Sir John Anderson. Noted jurist Falius Nariman described the majority. वो वहाँ का इंग्लैंड का ये दिया हुआ reference. Noted jurist Falius Nariman described the majority judgment of the Supreme Court as one of its most deplorable decisions, and further said it was इनका किताब का reference इसमें है, and further said it was the judicial pusillanimity at its worst. मतलब कुछ भी मतलब arbitrariness at its worst. The Supreme Court also noted that the dissenting judgment of Justice Khanna became the law of the land in view of the 44th Constitutional Amendment Act, by which Article 359 of the Constitution was amended and clauses 1 and 1A of Article 359 made it very clear that the right to move any court for the enforcement of the rights under Article 20 and 21 could not be suspended. Previously, the bar under Article 359 operated against moving the courts for enforcement of any of the rights under Part 3 of the Constitution. ये हट गया फिर. Another matter of some importance is that apart from Chief Justice A.N. Ray, all the other 3 judges who shared the majority opinion with the Chief Justice became Chief Justices of India later. जो आप बताए. Even though Chief Justiceship was due to Justice Khanna on the retirement of Chief Justice Ray, Justice Khanna knew the consequence of his dissent. देखिए, and he said to his younger sister about his dissenting judgment, I have prepared a judgment which is going to cost me the Chief Justiceship of India. In fact, it did. F.S. Falius Nariman.
इस बुक का नाम लिख लेना यार, थोड़ा इसको देखेंगे, पढ़ेंगे इसको क्या लिख रहे हैं.
Neither roses nor thorns.
चलो
H.R.
ठीक है,
Khanna.
उनका भतीजा तो बन रहा है, संजीव खन्ना तो बन रहा है.
But at least he had the guts to, say something when he knew that he would not be favored. Not Roses. क्या था बुक का नाम सर? Not Roses.
एक मिनट.
Not
Neither
Thorns.
roses nor thorns.
Neither. ठीक है, खोजूंगा इसको.
ये this is a must.
हाँ.
आगे क्या बोल रहे हैं? In fact,
it did. Falius Nariman noted it was directly as a result of the dissent in this case that Justice Khanna was subsequently superseded in January 1977 when it was his turn as the senior-most judge to be appointed Chief Justice of India. Contrary to the long-standing practice, he was not appointed Chief Justice of India. Khanna then promptly resigned. He had some self-respect.
Now, this was the main cause for collegium system in 1993. कौन बना?
इसके बाद
बेग.
हाँ. So H.M. Sirva in the Emergency Future Safeguards and the Habeas Corpus criticism wrote that the censor banned even publications of Justice Khanna's dissent in the newspaper. ये कौन सा तरीका हुआ सर? ये कौन सा तरीका हुआ?
अच्छा.
If a judge is dissenting, it won't be reported in the paper and people won't know, the country won't know about it. Such was the state of affairs, the sorry state of affairs at that time.
आंखें खुलती हैं यार, रियली।
देखिए हम लोग ये पढ़ रहे हैं, आज समझ में आ रहा है। आई नेवर न्यू दैट सच अ थिंग, आई कुडंट इवन कॉम्प्रिहेंड दैट such a thing could have ever happened, and none of us knew about this, that the newspapers can be strangled,
वी शुड थैंक गांगुली साहब फॉर दिस। ये तो
हाँ
कभी
हाँ हाँ
पढ़ने को नहीं मिला, गांगुली साहब ने लिखा है ना ये।
हाँ, लिखा है किताब तब तो पता चला, लेकिन ये
Yes.
खन्ना साहब भी किताब निकाले थे, लेकिन वो किताब भी बैन कर दिया गया। देखिए किताब बैन कर दिया गया, पब्लिकेशन जितने न्यूज़पेपर्स थे उसमें डिसेंट पब्लिश नहीं हुआ, ऐसा इमरजेंसी था। देखिए so it was a dictatorship sort of. Justice Khanna's memorable dissent upheld the concept of rule of law as being opposed to
ये राहुल गांधी के सिर पे मारना चाहिए इसको सबको, जो पब्लिक है ना, पढ़ करके देखो कि तुम्हारे
बेशरम आदमी है।
नानी ने क्या किया था। वो कहीं का।
एक आदमी ने अच्छा बोला, सर हम लोग पप्पू पप्पू करते हैं, लेकिन वो बदमाश है। वो दिखाता जैसे लालू प्रसाद जी थे,
हाँ
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 ठीक है,
हाँ
वो
हाँ।
जोकर लोग बोलते थे वो जोकर है, लेकिन जोकरी के आड़ में वो पूरा दुनिया भर का बदमाशी किए। सेम इज द केस विद राहुल गांधी। He shows that he is stupid, but inside he is very dangerous for this country.
जस्टिस खन्ना
I'm
मेमोरेबल
saying openly.
द कंसेप्ट ऑफ लॉ, रूल ऑफ लॉ बीइंग अपोज्ड टू arbitrariness and the learned judges was very poignant in his observation. Even in the absence of Article 21 of the Constitution, they
The
said that
state has no power to deprive a person of his life and liberty without the authority of law. This is the essential postulate and basic assumption of the rule of law, and not of men of all civilized nations. Without such sanctity of life and liberty, the distinction between a lawless society and one governed by laws would cease to have any meaning. The principle that no one shall be deprived of his life or liberty without the authority of law is rooted in the consideration that life and liberty are priceless possessions which cannot be made the plaything of individual whim and caprice, and that any act which has the effect of tampering with life and liberty must receive sustenance from the sanction of the laws of the land. From the aforesaid proposition, Justice Khanna defined the contours of the rule of law and held that the rule of law was not a nebulous concept, मतलब बहुत दूर कुछ unattainable concept. According to the learned judge, the important facets of the rule of law, absence of arbitrariness, and the need of the authority of law for official acts affecting prejudicially the rights of individuals. Along with that, the learned judge held that the power of the court to grant relief against arbitrariness or in the absence of authority of law in a matter relating to the liberty of the subject is a normal feature of the rule of law, and pointed out that government under law means the supremacy of law over the government. Government under law means the supremacy of law over the government. The learned judge also said that the powers of the executive should not only be derived from law, but should also be limited by law.
Hmm.
Unlimited, unfettered powers cannot be given to the legislature, or the executive, sorry. To the executive. Therefore, in formulating the concept of rule of law being antithetical to arbitrariness, Justice Khanna's dissenting opinion heralded the subsequent expansion of the doctrine of equality by the Supreme Court in Maneka Gandhi, that arbitrariness is the reverse of the rule of law. In addition, Justice Khanna's dissenting opinion, by recognizing the locus of the detainee to approach the court for redress, expanded the concept of access to justice. उसमें access to justice बंद कर रहे थे ना लोग,
Hmm.
and thus strengthened the concept of procedural due process. But the majority opinion, by withholding access to court to an aggrieved person who was illegally denied, देखिए illegally denied वो बता रहे हैं, of his liberty, took the most cramped view of liberty. This is an instance of a very constricted constitutional adjudication during emergency. It has already been noted that the dissenting opinion of Justice Khanna has become the law of the land in view of the 44th Constitutional Amendment Act. If we look at the statement of objects and reasons of the 44th Constitutional Amendment Act, it is clear that it was inspired by the historic dissent of Justice Khanna. Relevant excerpts from the statement of objects and reasons are excerpted as a further check against the misuse of emergency provisions and to put the right to life and liberty on a secure footing. It would be provided that the power to suspend the right to move the court for the enforcement of a fundamental right cannot be exercised in respect of the fundamental right to life and liberty. Towards the concluding portion of the dissenting opinion, the learned judge made it clear that the question of utmost importance and gravity, and a question which is not only important for interpreting the Constitution, but which has an impact upon the basic values affecting life, liberty, and the rule of law, was raised in the case, which, according to the learned judge, was whether the law speaking through the authority of the courts would be absolutely silenced and rendered mute because of the emergency. In the penultimate paragraph of his opinion, the learned judge referred to the observation of Chief Justice Hughes that dissent in a court of last resort is an appeal to the brooding spirit of law, so that in future days, important, a later decision may correct the error which has crept in into the majority opinion. This has really happened in the case of the dissenting opinion of Justice Khanna. By a future amendment of the Constitution, his dissenting opinion has now become the law of the land, and the majority opinion has virtually lost its relevance in the context of the 44th Constitution Amendment Act. About the role of the higher courts in dealing with preventive detention during the emergency, Sirvai observed that the high courts rose to the occasion, but the Supreme Court sank. However,
Correct.
one dissenting opinion in the Supreme Court provoked the 44th Constitution Amendment Act to ensure access to justice of any person for enforcing his rights to liberty, life and liberty during the emergency. Thus, the eternal values of civil liberty and freedom have been recognized in our Constitution as non-derogable standards and are to be regarded as principles of jus cogens. That means in international law, jus cogens would be that there should be, I mean, justice in consonance with the principles of law as regards right to life and liberty. यही तो होगा sir.
Mhm.
F.S. Nariman rightly found some similarity between the decision of ADM Jabalpur and that of Dred Scott, rendered more a century ago in 1857 by a 6-2 majority of the American Supreme Court. The majority in Dred Scott held that a black person could never be a citizen of the US. अच्छा ऐसा था पहले. A criticism of the view by Abraham Lincoln got national attention and ultimately helped him win the presidential election, which changed history.
एक बार क्या किया? A
ये
strong criticism of this view by Abraham Lincoln. Abraham Lincoln was anti-black. What? क्या बोल रहे हैं?
no, he was not anti-black. He was pro-black. So he had a dissenting view, and he won the election because of that.
अच्छा, criticism, okay.
हाँ,
And
in
what help him win?
just Justice Khanna was dissenting. Similarly, Abraham Lincoln was of the view that no, blacks must also have access to justice.
But he sacrificed his life, ना? जैसे खन्ना ने अपना chief justice sacrifice किया.
Same, he's equating Khanna with Abraham Lincoln. यदि Abraham Lincoln नहीं करता ये चीज, तो blacks का कोई आज rights नहीं रहता. Similarly, Justice Khanna dissenting view paved the way for the 44th Constitution Amendment Act, which took away the powers of the emergency.
Both have sacrificed in one way or other. Abraham Lincoln was shot dead. And
this gentleman was not promoted as Chief Justice.
Yes.
And he had to resign to save his dignity.
So whenever
Being
you
the senior
do something for the change of the
do something
society,
good for the country, you have to suffer.
You have to suffer. Yes. In both the cases, powerful dissenting opinion brought about far-reaching changes.
Far-reaching changes in these two democracies, मतलब India and USA.
Yes. हो गया भाई, खत्म, बंद करो. अच्छा रहा आज का?
बिल्कुल अच्छा रहा सर. आज तो बड़ा अच्छा सेशन रहा. I do not know whether our viewers will agree, but if they have any questions, they can always write to us.
हम्म, चलो बंद
कमेंट
करो।
सेक्शन में कुछ है सर?
नहीं, कोई न्यू एथिस्ट
अच्छा,
आया, पता नहीं क्या है न्यू एथिस्ट साहब कौन है।
it doesn't matter, sir. It's all right. At least he's saying namaskar.
So we are closing this stream, and
Thank you
we'll
very much,
take
sir, for affording me the opportunity of speaking.
we'll take at least 10-15 minutes break, and then we'll go for another stream.
Sure, sir.
Okay, thank you. If you
Sure,
like
sir.
this
Th-
stream, then please like it so that it reaches to the maximum people. We are making lot of efforts to dig this type of judgments and to provide the explanation to you. So please like,
And,
share, and
and in the
subscribe.
comment section, if anybody has a question or if anybody wants an elaboration on what we have stated, you are always free to express your opinions and offer your valued comments so that we have an opportunity of, I mean, giving you the proper perspective in which these judgments were delivered and the constitution has been interpreted.
Thank you, Advocate Majumdar
Thank you,
ji.
sir. Thank
Bye
you very much, sir.
bye.
Thank you, sir.